Now back to the show. This is The Law Show on CL 650.
And welcome back to The Law Show on CL 650. We're talking about wills and estates, but we're making it fun.
We try to.
All right. We have in studio Alyssa Lockhart, partner at Macquarie LLP, and Leah Donaldson, senior associate at Macquarie LLP. And we've talked about blended families, why you need a lawyer. Now we're getting to the other end of it when someone has passed away and you're utilizing the executor role. So explain that role in a will and what that person needs to do.
So a will speaks from the moment of death, and one of the first things identified in a will is the person who you leave behind to execute your wishes, the executor. The will doesn't necessarily give the executor authority over the movement and liquidation of your assets from death, though. That's what the probate process is all about. So the executor's first step, aside from arranging for the funeral and identifying family members, one of the first things that we have to do is move to obtain probate in order that we can then liquidate the assets.
Now explain what probate is. As a layperson, that doesn't mean anything.
Right.
So that just means the process of running the will, right? Going through the steps of the will?
Probate process, estate administration is the process of executing the will. But the probate process is where you disclose the will to the probate registry, which is a court registry here in BC, and they determine that it is the last will of the deceased, that you are the executor intended to be named, that you're an appropriate executor. There's no claim against you with respect to things that could cause you to be an inappropriate executor, and that there's no other reason you shouldn't continue to be an executor, like your own mental incapacity.
So this is an important job. And how many people find out that they're the executor after the will has been read? What percentage?
Right. With my clients, I hope the percentage is 0. I always encourage people to ask before naming someone. It's a difficult job. You know, a lot of people want to name their oldest son, for instance. It's a very traditional notion. But if your oldest son is not capable because he lives in Europe and works a 16-hour day and has no ability to attend to these matters and it will just languish, not a great choice, even though the relationship is there. So if your oldest son is not capable because he's never really been that good at talking to the family members, or doesn't know the first thing about retaining a realtor to sell your house, or how to find an accountant.
Not sophisticated.
Yeah. So we would look at, it's a job like any other job with duties, and we want you to select the person appropriate to get it done efficiently, cost effectively, and without damaging any of those important family relationships.
Is it better to get somebody that's a family member but outside of that nuclear family, like a cousin or an aunt or an uncle, or is that
I wouldn't
often the
say
case?
better. I would say that the person who's right for the job might have any relationship to you, but they'll be right for the job because of the things that I've already described.
And so some people use friends, and
Yes,
Some
they do.
people do.
Yeah. They sometimes pay a professional executor, so a trust company can do it if there isn't anyone appropriate to choose. It's usually, a good choice is someone, like Alyssa saying, that, if it isn't anyone in your family that's capable, then it's somebody that's neutral, that will carry out your wishes, that is somewhat sophisticated, able to handle the duties, because it is a big commitment. It's a long process.
What is the timeline?
That depends on the executor.
It really depends. I have one fabulous estate from a very public family. The death occurred before I was out of middle school, and the will was properly probated, but only a decade ago, additional assets came to light. So they had used a very well-known firm. They'd done all of their due diligence, but this asset was just hidden. And now we have this great estate saga because a lot of the beneficiaries who were themselves in their 50s or 60s at the time of the death have now passed on, and some of their children have passed on. So it's really interesting to see the flow of the assets down through the multiple estates. So, the average estate We would like to see that you identify the assets, ascertain assets and liabilities essentially, that you move to identify the whereabouts of all the potential beneficiaries, take the application for probate process seriously and get it in and get it done within the first year after a person's passing. And then when we liquidate and distribute, getting consents from the beneficiaries, file the taxes that need to be filed for the deceased or for the estate essentially becomes its own taxpayer. Maybe another year has passed.
Really, that long?
Yeah.
So this is somebody that has to have the wherewithal to deal with professionals, whether they're real estate agents or they're lawyers or anything, right?
Yep.
The tax man, but also don't overstep their own abilities and say, oh, we've got a 5-acre lot in Langley. Let's subdivide it and build houses and sell it, and then everyone's going to be rich. Because you've had people that go too far.
Yes.
Yeah.
We do.
Yeah.
So
and that's when that opens a litigation door again, and as well as delay. So we do have several estates that I'm dealing with presently now that are basically become litigation files only based on delay. So the executor, they chose the wrong person. That executor just can't get on top of things. Maybe their life is, not in a position where they can devote the time needed. So years will go by before beneficiaries will hear anything.
So if you're named as an executor and you have this and you have a crazy life, maybe, whatever it is, you just have a very busy life. Can you pass that on to somebody else? Like, how do you deal with that one? When this lands on your feet and you maybe didn't even know about it, can you say, wait a second, not for me?
Right. You can renounce. You can abstain from acting, as it were. Once you have what we call intermeddled in the assets, affected the finances of the estate, then you actually have to have a court allow you to remove yourself. But for the very first step, if you look at this and you say, well, I've read the will, it looks really complicated. There's a lot of things I have to hold for minor beneficiaries for decades to come. I don't want to do it.
But what about the initial stuff, like the dealing with the remains and the funeral and the payments about that? Once you get into it, are you still obliged to go to a court and be removed?
I don't know, Leah. I think that in our practice, we take a fairly broad view of that. If someone assists in arranging a funeral, that doesn't make them bound to jump in and address all of the financial aspects and become the executor. That could be done by a friend or by an immediate family member. A lot of the times the will say who should arrange the funeral, and it might be someone different than the executor, but that isn't necessarily what we mean by intermeddling. Is that, would you agree?
I would agree, yeah. When we're talking about intermeddling, it's basically an executor has been trying to deal with the estate for, say, 2 years. Maybe they've made some decisions. They've sold the property, and then they've decided, oh, never mind, I don't want to be involved in this process anymore. That's where we see a court say, no, before you just step back, you're going to have to account, essentially, to the beneficiaries. And if they don't agree to that accounting, they have to get a court order.
Well, I have found that wills and estates law has some great stuff. Intermeddling and hodgepodge.
Hodgepodge.
Is it hot?
Hodgepodge.
Hodgepodge.
Hodgepodge. All right. Any other ones you want to pull out while we're at it? Any good names?
Oh, they don't come off the top of my head, but just keep me talking long enough and there'll be something in Latin for sure.
So with the timelines, there could be some pitfalls. Can someone get pretty deep into this and then realize, they don't want to do it? Or what are some of the major pitfalls you see with an executor that in your practice?
Well, I think that the pitfalls are sometimes people get very deep into it thinking that they're reading the will as a document in order. And so I'll do this first and I'll do this first. If you give away assets, because the gift clause is at the beginning of the will, that's fine. If you have already received probate, if you have consent of beneficiaries that may need to consent, if you've considered the tax consequences of the sale or liquidation or transfer of other assets, and if there are sufficient funds to pay for those taxes, if you've gifted away an asset that now needs to be clawed back in order to be sold to pay the deceased's taxes, you've got a problem. So a lot of the times...
Leah.
Yeah, well, no, that's still an administration
Okay.
issue. That's not so much litigation. So we get a lot of that, actually. We do have calls from people who say, I've done this and this and this already, so now I need legal help. And we say, okay, so you definitely need legal help because you've done this and this, that's totally fine. But that third this, that shouldn't have happened yet. So we do see people struggling with that.
Okay, so on the estate side where you're setting it up, so you're there to hold their hand to get the will drafted properly, but also on the other side to make sure that you're doing it in the right steps.
Right.
So is that a good piece of advice? If you're in this situation, an estate lawyer can look at it and say, here's your roadmap of what you need to do.
Absolutely. Sometimes we have people come in and they say, we really want to do as much as we can ourselves, but we don't know where to start. And so we will give them a roadmap. Other times people come in and they say, I'm actually very busy and I will do this because I'm the only one of my siblings who's capable of doing it. I'm the only one that lives close by or I'm the most sophisticated, but I want to be as hands-off as possible because I anticipate problems with my siblings if I'm running things and if the money is flowing through my hands. So you handle it. And so we'll take on a file and we'll do the administration and we'll bring the client in to sign the documents. We'll have investigated the assets or they'll bring in the asset list and we simply paper that. But when we do the liquidation, a lot of times people ask us to liquidate those bank accounts, RRSPs or RIFs, TFSAs that are left to the estate directly into the law firm's trust account so that they specifically don't pass to the executor as a trustee.
Keeps it cleaner.
It keeps it very clean, and our records keeping, because the Law Society requires it, is really solid. So they're asking to buy that from us, to buy that trust record, which then doesn't require them to have to explain to the siblings.
And I guess with large estates, it makes even more sense, right?
It can. Larger estates can flow very quickly, depending on the nature of the asset, but other times they'll run for 7 or 8 years just because of the nature of the assets. Do we have to sell an operational business? Do we have ongoing litigation with the tax court because of a business venture gone awry before the death of the deceased? So there's a number of things with high net worth clients and their estates that can lengthen the process.
All right, we are talking about wills and estates. We have Alyssa Lockhart, partner at Macquarie LLP, and Leah Donaldson, senior associate at Macquarie LLP. We're going to talk about unusual assets an executor might have to deal with next on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.